Uh, in this video, we will start uh, and quick recap from section 15. So section 15, here I have keyword that is reflecting marking. So when the design is registered and the product is in the market, then the proprietor or the design inventor, whoever it is, he need to have a marking on it that we know, and that is discussed in this section 15, right? So what section? So what is to be there in that marking is discussed in 26. So here it tells us that your marking should have either REGD or RD are registered and designated, and its design number should reflect in that. If it is not written, then you are not eligible for any damages. Your design will work, but you will not get damages. But there are two exceptions in this. What is the exception? One is for textile products because they wash it and again. So it is not possible to write the design number there. So in textile products, it is exempted. And also in charcoal products or some other products which are fragile, there also it is not required to write there, right? So it is not possible basically. That's why these two are exemptions, such fragile things, there is an exemption for it. Now, if we look at section 16, it is talking about good faith. What 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 is good faith? Where it is coming in this means, when let's say you have a design and you have shared with some other a friend or someone, then that guy has taken that design and published in a documented way. Either it is an article or it is a publication. Then because you have shared it for a good faith on a good faith, but he breached it. If you have a documented proof, then you can show it and claim that this is a design which you have proprietor, right? So based on that, you can uh, find the design which is not considered as an anticipate because of good faith. Okay. No, but yes, here you have to keep in mind that your design should have a novel feature. That is, it should be original and it should have uniqueness. It should not happen that you tell something in good faith and it turns out that that is not original. So rule number 12 talks about it. Okay. Rule number 12 talks about novelty. That will be checked, but okay, that's it. I think that is enough to understand from that. Now, next section 17. It is very simple. Simply put, to access the register, you need to file form number 5, which costs 500 rupees. If you want to certify, if you want certified copies of any design from the register, you must file form number 16, which also costs 500 rupees. Okay, if you want certificate copies, you have to file form 16. If you want to access, then you have to file form 5. That's what it says. This is mentioned in rule number 27, which is mentioned in the this. And this happens post grant registration only, right? Yeah. Now, section 18 takes that if you want to check the enforcement or status of the design, for example, whether the design is still valid after 10 years, or it is revoked, or it is withdrawn, or abandoned, or what is the current status is, if you want to find out, then you need to file form number 6 with the design number. If you have design number, file form 6, you get the details as per rule 28. You must pay 500 rupees to receive the information about the design's existence and its status. So form number 6 and form rule number 28 and 500 rupees. Now, if you don't have the number and you are opening a company, you will need to proceed differently. How you assume that you want to have the design from somewhere and you want to find out what it is, then you need to know the design. Okay. Yeah, if you want to get that, so you have to pay 1,000 rupees, and controller will provide you similar design within a week. So if you are opening a company, you need a product, then you ask controller that you need certain information from that, and you don't have the number. You request him with by paying 1,000 rupees and request with the form 7, then he will provide you details. Okay, the controller will provide you details within a week. Uh, Whether it is number 7, section number 17 or section number 18, both are same. As per after registration, you will get these things. Now, if you will get the documents within a week, as I said. Let's talk about section 19. Here it is about cancellation, right? Now, cancellation, uh, you have multiple things that you have to keep in mind from rule number 29 actually. Okay, let's see. Now, okay, which section? Section 19. So assume that the design is registered and you are interested person, and you want, you will know that the design has been published somewhere else, or somewhere you have seen some design, and you know that that design already exists before the design which is registered, and that means that there is a prior art kind of thing, as we discussed in patent act, right? Now, based design like that are also published somewhere else, or whether it is a research paper, whether it is a news article, whether it is published anywhere in the world, whether it is coming under section 2D and 24D, which is you where you want to raise objection based on certain conditions, then maybe it is also scandalous in design matter, then you want to raise that point to the controller. Then on these grounds in the design of another, and you want it to cancel it, then rule number 29 will help you in doing that by filing form number 8. That is, you will become a petitioner, and the proprietor becomes the defender. He need to, if he need to defend, he need to defend. So petitioner, that opponent, will file form number 8. A duplicate copy will be sent to the controller and a copy to the registered proprietor, the owner. Then there will be a loop where the controller need to hear to the already the registered proprietor. Within 1 month, he need to reply, but form number 18 he need to use. Uh, Up to 3 months he can do that, and a copy to the petitioner also will be sent. Then again petitioner can reply to the controller within 1 month, but again form 18 up to 3 months he can use. Copy of that will be again sent to the the registered proprietor. If there is a translation of that document is required, that also need to be given. And from then the controller will hear 10 days for hearing notice he will be giving, and will be, if you want to attend for that hearing, then you need to file form number 20 and publication document in hearing before 5 days. If you have any publication document, you want to show that to the controller before the hearing, 5 days before, you have to give it to the other parties. So these all things are covered in section rule number 29. I feel you should revise this 29 thoroughly. There are possibilities you may get different questions in which the same design. Okay. Okay, so section number, I think I mostly covered what goes under section number 29. Okay, for that you have to pay 1,500 rupees. So by filing form number 8, by giving these evidences, you can cancel this any design according to rule number 29. This design, I think it is very simple. That's what they are saying. Now the petition filed. Okay. Now let's look at section number 20. Now, section number 20, what it talks about is, let's say what Patent Act says, same thing Design Act also says, that the government E will be considered as a natural person. Now, because that once that happens, okay, now once that happens, next section talks about uh, it- mm, if the government also uses your design without your consent, okay, then this becomes a government also infringing your thing. But yes, one more line also added here, that same privileges that were in the patent in section number 99 to 103, you will have to give all same privileges to in the Design Act. Said government can use it, can acquire it, and can you can say nothing to it. But yes, whenever it uses it, will provide information or it may give compensations, right? Section number 21 says that if you publish your design in an exhibition, so in simple terms, exhibition before and exhibition after, what the applicant or the proprietor should do is, I mean, I think before it is applicant, after it is a proprietor. No, because it is not yet registered. There, I am not talking about it, about the proprietorship. Let's talk about applicant. So exhibition before 6 months, he need to inform to the controller that he want to present in that exhibition. That request he need to put. And after that exhibition, within 6 months, he need to file the registration. Then only it is possible. And using Form 9, he need to file by paying 500 rupees. Okay. Next thing, that is section number 22, which is called piracy in the keyword, right? So there is another word, SIP. What piracy means? Either it is without permission, sells your design, publishes your design, or imports your design. So these three things are coming under section 22. And then it is considered as piracy. And first time there is a fine for the piracy, there is a first time 25,000 rupees. If the same is repeated, then maximum up to 50,000 rupees it can be fined. This is written under rule number 29. Okay. Now section number 23. If I have a design, now I am threatening you again and again that don't use my design. I have the design, otherwise I will file a case. Such kind of threats if I'm giving. But those threats are without a proper ground. There is groundless threat if I am giving to you, then you can ask for injunction from the controller or from the court based on the section 23. Now section 24 is talks about all the forms and its related fees. It's best to see section number 24 in isolation. Okay. And rule number 5 gives you all the details about it. I request you to read separately. Section number 25, it talks about trust notice. Okay. What it is, okay. In register, there won't be any uh, history where you have a trust notice shared between someone that is not registered in the register. Okay, this is similar to Patent Act 60 section 67. Now, section number 26 talks about inspection. We have seen section number 17 also talks about inspection. But here 26 is more stronger in a sense that you will get from section number 17, based on 17, you will get design certificate, you can get it, right? Now, if you want to take information about mortgage, you want to get taken assignment, someone has taken license, all the affidavits about that also you can get such information you can get from by using form number 15 as per rule 44. And here you have to pay 500 rupees to get it processed. Okay. Once you file it, you will get within 1 week. You will get information. Okay. This is we are talking about 26. You will get within 1 week. Now section number 26 talks about reports of the controller. Now section here, these are confidential. That's what is the information given in section number 26. Okay. I think this is 27. I'm sorry. This is about 27. Controller will have all the confidential matters which he will not go out. Now section number 28 talks about no publication in case of abandonment or withdrawal. If the controller accepts that they refuse your design for any purpose, or you are not able to complete all these things in 6 months as per rule 21, then in that case your design will not be published and your design will not publicly available to anyone. If incomplete, it is assumed that you haven't filed. Such a situation will arise, okay? Because it is not publicly available. Next thing is rule number 18 also here we given that the first examination report is also made here. In the first examination report, within 3 months, if you don't reply, then your application gets withdrawn. That is the thing. In rule number 21, I want to say again that 6 months from the date of publication, if you don't complete the incompleteness, 6 months from the date of application, then your application will be considered as abandoned. Now, section number 29, if there is a clerical error, if you want to rectify it, use form number 14, pay 500 rupees and you can correct that. Now, section number 30 is about assignment and transmission. For that, you can use 10, 11, 12, 13 forms. I will tell you what those forms are. Now, form number, if you want proprietors to be proprietorship, then you have to file 11. If you want to add license or mortgage, form number 12. If you want to attach any additional documents with it, then form number 13 will come in this. Okay, and freeze. Okay, if there is now situation is like in the design, you will file multiple designs from a single class and different classes you will file, right? Now for the first application you will pay 500 rupees. For the second onwards you will pay 200 rupees. That is valid for all the forms 10, 11, 12, 13. Okay. Now, in case of rectification, if you want to rectify anything, section number 31 talks about it. If you want to rectify your application, if there is a mistake and you want to rectify it, then the rectification of that specification is done by filing form number 17, whose charges are 500 rupees. Now, you can also do, if there is no objection, can do that. Okay. By filing form number 19, who charges 100, you can do objection. So this thing is written in rectification. Simple. Within 3 months, you have to do that. Now let's talk about 32, where I have mentioned it as code. It actually means the controller has the power of the code. I think just like Patent Act, section number 77, the same is here for 32. The controller has the power as a code. The same thing is written here. Now he can give summons and he can call someone for the same thing. As section number 33 talks about hearing. Okay. Now this hearing happens. Section number 33 talks about hearing. If the controller has any adverse effect on your application, then hearing will be called for, then action will be taken, then only after hearing only it happens. Now form number 20, if controller has any issue under which class it has to go, then controller will request central government to for the help. Now section number 35, moral ethics, on that grounds the application can be refused by the controller. That's what 35 it talks about. Section number 36 says High Court, if you don't agree with the controller's decision, then whenever the controller's decision comes, you can go to the High Court in 3 months. It is mentioned, right? Yeah. And in those 3 months, the time that you occupy with the controller, that time will not be considered. Rule number 44 will be applicable here. Section number 37 talks about the evidence. Evidence is taken in 3 ways. Remember, orally, affidavit, or cross examination, similar to section number 79 of Patent Act. Now, section number 38 talks about if you want certified copies from the controller, then you will have to file form number 15 with the cost of 500 rupees. And if you want sealed documents through patent office, then you have to file form number 39 under section 39. You have to form number 16 you have to file with 500 rupees. Now section number 40 talks about post. That is, whenever communication you will do to the controller or the patent office, then you will post, not courier. Section number 41 talks about infant and lunatic. If there is there is a small child who is not an adult and there is an application grant on his name, then their legal guardian or authorized person by court will take actions on their behalf of in case of any infringement suit or revocation proceedings. Now 42 is a restrictive conditions. Assume that I have a patent and I have a design. The design, the same is in the case with design. The Patent Act has 140 section and the Design Act is 42. Same to say that if I have a design and you want to take a license in my design, then I say that you have to take my design, then you have to purchase the parts of my other design. This is the restrictive condition, right? You have taken license for one design and I am forcing you to take another design which is dependent on that, or I'm asking you to take the spare parts of that, I'm forcing it, then that is restrictive condition which is not acceptable as per Act, which I cannot say. So I can't even say that if you become a licensee, you can put this restrictive condition on someone. You can't put it either. That also you cannot do. If you put such condition and I am not a party there, I don't even know that you put this condition on someone, then you and those two are infringing on me, right? That is, I can file a case against you and even on that person who is taking things from you with such a restrictive condition without my information. So without my information, if such activities are happening, because license is given to operate, not to give additional restrictive conditions without my knowledge. Okay. Without my consent, these all things are happening. Then it comes that if the contract was made before Design Act, then it will be valid for 1 year. But if that is before 2000 and this the Design Act came in 2000. Now this is what before that what happens is different, and after 2000 there was a contract that you have taken things from me. So then after the Design Act came, it was valid for 1 year, that is 2000. And for repair parts, if you have any my design, I can give you this condition for repair parts, that you have to take repair parts from me only. This is what is called relaxation. In both cases, in the patent case as well as here, in section 140 of the patent and 42 of this section act as well. These are same and same to same conditions. Okay. Whatever conditions I have told you, I think under this 42 section, the these you will see in the patent and design alike. Now section number 43, which is related to patent act or advocate, you go to the your proceeding on your behalf, patent agent will go, that is related to that. And 44 is a matter of conventional application. This we talked about in the beginning. Okay. Here comes, here more importance is given to the, I think, reciprocity. Okay, we will see. And in 43, the patent agent has authorized and there is no fee, but form number 21, I forgot. 21 should be filed without any charges. In 44, conventional application means that first application, let's say he filed in US, then you can file in India within 6 months. It will be called a conventional application, but you can do it only when the application that has been filed in India. In the US is allowed to be filed in US in 6 months. That is, if there is a reciprocity, that's what it is. Then you can file this thing. 45, in which form number 18 comes from. Form number 18 is to submit form number 18. I think I have made mistake here, but we can consider this, right? Now, form number 18 is to submit the priority document that you have filed as an application in India within 6 months. Then you have to submit any prior document. So prior document, you have 3 months to do it. Filing with form 18, and charge of this is 200 rupees you have to pay. Then comes the form 45. 45, which talks about Parliament. Whenever the design will be, there will be patent of intellectual property. So your design can be revoked and its publication can be removed. 47 talks about the central government can make rules. For this, the design rules can be amended as it happens in the Patent Act. That act is amended by the Parliament. Sorry, the rules are amended by the central government, and section 48 talks about repeal. If we are going to another act, then or when any rules are amended, this is repeal. This section 48 will be used. In that case, the old application will run on the old rules, and the new application will run on the new rules. In between, pending application will also run on new rules. This was said in section number 48. Okay, I think I have completed all the sections. Thank you.